Here before, back in 1998, I advised the Icelandic Medical Association, which was fighting a proposal, a startup company called Decode, which raised millions of dollars from Boston venture capitalists, and had the idea that they'd hoover up everything in Iceland, they'd build a centralized medical record system, and they would pay for this by selling access to the records to Roche, the Swiss drug company. The value proposition was that Icelanders have got good family trees going back to the foundation of the country 1,000 years ago. They have high prevalence of some inherited disorders, and the idea was that by having the med records, the genomic data, and the family histories, you had a unique lab for doing medical research. And that didn't work, and one of the reasons it didn't work is that the Icelandic Medical Association persuaded 11% of the citizens to opt out. And then a case went before the Icelandic Supreme Court, which decided that on the basis of European human rights law, the same law as this law here, and such systems should be opt-in rather than opt-out. And that caused the system to collapse. A small number of people in Iceland made very large amounts of money, though over a third of the Icelandic population lost a substantial amount, because when the stock price of Decode hit a bubble, lots of people bought shares and then it went pop. And their money was gone. Now, one of the most important cases here is the IV Finland case of the European Court of Human Rights, which became final in 2010. Now, Ms. I was a nurse in Helsinki, at the university hospital there, and she was HIV positive. Unfortunately for her, the systems in the hospital there, like systems being deployed all over the UK now, let all clinicians see all patient records. And so her colleagues found out about her status, and they ostracized her and hounded her out of her job. So she sued for compensation for wrongful dismissal. The court in Helsinki said, well, that's your tough luck. We made regulations about how the hospital system should be, and they abided by those regulations. So she went to Strasbourg, and Strasbourg overturned this. They said, no, the Finnish government should not have arranged things in such a way. It should have seen to it that everybody had the practical right to see to it that their medical records would not be shared with outsiders, with people outside the immediate care team. So like it or not, and the government doesn't, we've got the right to restrict our personal health information to the clinicians who are caring for us. Now try and exercise that right in the NHS and you'll find yourself without care.
Exactly.
So, again, we've been here before in 95, 96, when Fleur and I were fighting Stephen Dorrell's attempt to centralise everything. And in 2002, a 40-minute meeting in Downing Street led to the decision to run a national programme for IT, which wasted billions and billions of pounds, the biggest public sector IT disaster so far in human history. And the idea was to replace all the computer systems in the NHS with standard ones, a single electronic health record with access for everyone with a need to know. That slogan actually goes back to 1992. Is anybody here old enough to remember Ray Rogers?
Yes.
of unblessed memory. Bomb the place. Hey. Anyway, so what we saw was that billions were wasted, and the smart suppliers like Accenture dropped out at the start, and you ended up with huge lawsuits, and the flagship software, which they worked on for years and years and years in Bangalore, ended up not working properly. But nonetheless, we got some stuff fielded, and this is already causing problems. Over half of all GPs in Britain are now using systems which are hosted. That means that instead of your record sitting in your GP's surgery, GP comes in the morning, flicks the switch, the system comes up, and your records are hosted in BT's data center, or in EMIS's data center, or somewhere else where the customer is not your GP, but the Secretary of State. So a very crucial aspect of control has been lost. What else do we see? Well, we see that in an increasing number of hospitals, receptionists can read your psychiatric case notes. Now, this is something that Fleur and I warned about back in 1995, that you had to have more than one record per person. You had to have a separate way of handling sensitive stuff. As the thing that Terry was talking about what happens about the 14-year-old who wants their gonorrhea treatment to be in a part of the record that the mummy can't see. You can't do that if you've got a single electronic patient record. You end up trying to put in fudges after the fact, such as sealed envelopes, which don't work, because Whitehall doesn't really want them, so they never get implemented or never work properly. So how does this happen? Well, the theory is that access is based on a role, a legitimate relationship, and the role, receptionist, needs access to the patient's records so that she can receive him, and there is a legitimate record relationship because the patient's standing in front of you. So if the record is just one record, then the receptionist has access to your psychiatric notes. End of story. Right, that's the problem with that architecture.